ग्रेट। अब फिर ये तो आ ही नहीं रहा बच्चा पीछे। एक मिनट।
Good evening, friends. Myself CA Raj Chawla, organizer of this webinar on Sabka Vishwas under GST. We have with us CA RK Bhalla ji, our speaker on today's topic. CA Bhalla is a very senior chartered accountant. He has already written 3 books on GST. First one is e-way bill and its analysis under GST Act. The second one is audit under GST Act with the annual return, and third one is authority for advance ruling under GST Act. And now his new book, this Sabka Vishwas Legal Dispute Resolution Scheme Rule 2019 is under printing. Very soon it will be available in the market. So I request Mr. RK Bhalla to please deliberate his topic and discuss all the query related to this scheme with our members. And members, you are requested, if you have any query, please send your query on our WhatsApp group. I will request Mr. Bhalla to please reply all of your queries, and even after this webinar, if you have any query, you can send on our WhatsApp group and he will try to resolve all your queries. So once again, I welcome you all, and I request CRK Bhalla ji to please start his deliberation. Thank you.
माइक कहाँ है? ये कैसे ऐसे ऐसे आवाज ये माइक ऐसे आ जाएगी आवाज या कैसे लगेगा? वहाँ देखना आवाज आ जाएगी। Thank you, Raj Chawla ji, for providing me an opportunity to interact with my professional colleagues, my dear professional colleagues and friends. This time, the government has announced a good scheme, Sabka Vishwas Legacy Dispute Resolution Scheme 2019. It is not new, and it is not the first time that this scheme is coming. Earlier also, these types of scheme was come because the government wants the pending litigations and the government revenue in appeals, which is stuck up for quite considerable years, that should be sorted out. And this scheme, this time, provided a huge relief. The finance minister, while presenting this finance bill, was concerned that more than 3.75 lakh crore rupees is stuck up at various stages under appeals. And government is keen, due to GST regime comes, so that they can sort out under the old regime disputed as early as possible. They want to achieve this object by introducing amnesty scheme under this. If we see this scheme carefully, then we find there are two aspects in the scheme. One is amnesty scheme, which is like voluntary disclosure, and other is regarding settlement of disputed pending disputes. And this scheme also provides immunity from plenty interest and prosecution. To my mind, this is the best scheme, and assessee should avail the advantage which the government is providing to them. Now question comes, what kind of cases, appeals, tax dues, tax in arrears are covered under this scheme? First of all, we should know that The cases under the Central Excise Act 1994 or Central Excise Tariff Act 1985 and Chapter 5 of the Finance Act 1994, all cases under these statutes are covered under these schemes. Central Excise, Central Excise Tariff Act and Service Tax. Under this enactment, the appeals and dispute pending with the department can be sorted out along with 26 cess. 26 cess is also covered. Such, for example, I am doing the Agriculture Produce Cess Tax, Coffee Act, the Mica Mines Labor Act, Rubber Act. In this type, there are 26 cess which are also covered under this scheme. This scheme has 16 sections, 9 rules with 6 forms. Section 122, Section 135 of the Chapter 5 of the Finance Act. Now, before I take you the discussion on section wise, amnesty scheme, this cover voluntary disclosure, and voluntary disclosure, they don't have any benefit on the tax dues. They only get the benefit of the interest penalty and prosecution. Now, let us take this scheme sections wise. This section 120 of this scheme is about the title of the scheme that specifies that this scheme is called Sabka Vishwas Legislative Dispute Resolution Scheme 2019, and it will come into operation when the notification of the government is come. Notification number 4 of 2019, dated 21st August 2019 has come. That says the scheme will be effective with effect from 1st of September 2019, and Rule 3 says it will be applicable up to 31st December 2019. Section 121 specifies definition of the different words used under the scheme. The most important word is person, because Section 125 we go. Section 125 says all the persons shall apply under the scheme. When we read this Section 125, it speaks about person. They say all persons shall eligible to make a declaration. The important question comes, what is the meaning of the person? Who can make the declaration under this scheme? As a professional, we should know which act comes under this scheme. Central Excise, Central Tariff and Service Tax, and 26 cess. Now, second question comes, who can file a declaration under the scheme? Section 125 says all persons shall be eligible to make a declaration. All persons shall be eligible. Underline person. Section 121, subclause Q, explain the meaning of persons. Who can file a declaration? Person means an individual, an HUF family, company, society, a limited liability partnership firm, association of person or body of individual incorporated or not, the government, a local authority, an assessee. An assessee defined as under Rule 2 of the Central Excise Rule 92. And next is 11. Every artificial judicial persons not falling with the meaning of any preceding clause. So this concept is very clear at this stage in our mind. 3x, applicability 26s, and the person. Now it says, this is a definition of person, which I will section 122, which I stated just now, that says we can see from the chart the Central Excise Act, Central Excise Tariff, Chapter 5 of the Finance Act, and these are the 26 cess which are covered. Now, question remains there, who can file this declaration? Then our answer is under section 125. It says all persons shall be eligible to make a declaration under the scheme, but the following persons cannot file the declaration. Number one category, which have filed an appeal before the appellate forum and such appeal has been heard finally on or before 30th June of 2019. It means the appeals which were filed at appellate forum and hearing of these appeals have been heard finally on or before 30th June 2019. A question rises here. If appeal has been heard finally and due to certain reason orders had not been passed, and subsequently it has been restructured due to change in the appellate form, then we have to find the answer whether these cases are covered or not. The circular number 1074 is there. This is that the cases which have been heard finally, they cannot go for this declaration. And further, the persons who have been convicted for any offense which is punishable under any provision of the indirect taxes enactment for the matter for which intend to file a declaration. If the person has been convicted for any offense under the provision of the indirect taxes, then he is not eligible for filing a declaration. And further, SCN has been issued. SCN is issued to the person, and final hearing on that SCN has been taken place on or before 30th June 2019. I will explain all these things with the chart subsequently. Let me explain the section wise, then we come to the practice and commentary wise. Where SCN has been issued under the indirect tax enactment for an universal refund or refund, and where he has been subject to any inquiry or investigation or audit, and the amount of duty involved in the said inquiry or investigation or audit has not been quantified on or before 30th June 2019, and a person who is making voluntary disclosure after being subjected to inquiry and investigation, audit, and or having been filed return under the indirect tax method, whereas he has indicated amount of duty is payable but has not been paid. And further, where application has been filed before the settlement commission for settlement of a case, those cases are not covered. But where settlement commission has referred back the cases to them, which are not subject matter to the settlement commission, then their cases can be filed. They have given the list, which is important because this act is applicable to the Central Excise Act. They said the following tariff 202401, the fourth schedule of the Central Excise Act 1994, which covers and the person who are dealing in these goods are not covered under the scheme. These are list has been given by them. Here we can take the tariff item 24102710. Now, so let us go back with the sections, then we come on that. We were there. Yes. Let us take this also. When we file the declaration, then the question will come regarding the tax dues. So they'll say, what is the meaning of tax dues? For which we are filing this declaration, and the relief will be granted subject to this tax dues relief. It says the tax dues means the areas rising out of single appeal or where SCN has been issued as on 30th June 2019 and voluntary disclosure, and where inquiry or investigation audit has been conducted and they have quantified the amount and amount in area which has not been paid and area rises from more than one appeal and the department appeal. We can understand this by way of chart. Tax dues. SCN issue for duty 1000 and penalty rupees 100. Order is for 1000 and penalty is 1000. It means the SCN was issued and order is on the same amount. SCN issue for 1000 and penalty for 100 and the order was also for 1000 and 100. Then tax due is 1000 because there is a total waiver of penalty. A relief is given under this scheme in respect of the tax dues. So tax due then come 1000. If SCN is issued for duty 1000, penalty is 100, but order was passed for 900 and penalty is 100, then this tax due will be 900. A relief will be calculated in respect of this 900 only. Then the third situation is there. SCN for duty is 1000, penalty is 100. Order is for 900, penalty is for 900. A successive file against appeal against this order, and department also filed appeal against this order. Then tax dues is the successive file the appeal and the department file the appeal. Both amounts should be added together. That will be the tax due. That comes 900 the successive file appeal and for 100 department file. The tax dues come to 1000. Where another situation comes, SCN issue for duty is 1000, penalty is 100, which were confirmed by first. Then first appeal reduced it to 900, and the SECI move another second appeal, then tax due will be 900. अब ये अथॉरिटी इन्होंने बनाई है, now we come to thus, when tax dues has been calculated as prescribed under section 123 of the scheme, then question comes, what kind of relief is available to the SECI? That comes under section 124. Relief available under the scheme. Section 194 says relief is available under this scheme where HCN or one or more appeals is pending as on 30th June 2019 and amount of disputed tax due is less than 50 lakhs. 50 lakh or less than 50 lakh. Then 70% of the tax due is exempted. It is a very big relief. Then SECI has to pay only 30% of the tax due and get relief under this scheme, and therefore no interest, no penalty, no prosecution will be there. Where inquiry or investigation or audit was conducted and amount was quantified, then it is also 70%. Where amount is in area, it is 60%, amount payable as per return 60%, or SCN for late fee or penalty, where duty has been paid and nil, total waiver is given for late fee or penalty, or in respect of the voluntary disclosure, relief is only in respect of the interest and penalty. There is no relief in respect of the tax dues under the voluntary disclosure scheme. And my dear friends, we should understand when voluntary disclosure scheme, the designation committee will accept as it is, but when they will issue a discharge certificate in case of voluntary disclosure scheme, that discharge certificate absolve the person from all the tax dues and prosecution. But it's an important point. But if within a period of 1 year, if the department finds subsequently within a period of 1 year that the voluntary disclosure declarant has made wrongly or was not correct, then it will be assumed that there was no declaration of this scheme and he will be not absolved from other interest and penalties. Therefore, one should be very careful while filing the voluntary disclosure, while taking the amnesty scheme benefit and filing the voluntary disclosure, that should be correctly filed. Otherwise, 1 year period is there to reopen this issue. But in case of other declarant, when discharge certificate will be issued, that will discharge them from all the liability under this act. Where there is a more than 50 lakhs, then relief is 50%. But in case of SCN for late and penalty, where duty is paid and nil, in that case also, if it is more than 50 lakhs, even then entire fee or penalty will be waived. But in the case of voluntary disclosure, only interest penalty will be waived, and he will also absolve. All the declarant under this scheme are absolved from the prosecution. That is a big relief. Amount in arrears means the amount of duty which is recoverable as arrears duty under the indirect tax enactment on count of no appeal have been filed by the declarant against an order or an ordered appeal before expiry of the period of time of filing the appeal. When the time for filing the appeal has been expired, that amount becomes amount in arrears. Where an order in appeal relating to the declarant attaining finality, or third category is the declarant having filed a return under indirect tax enactment on or before 30th June of 2019, wherein he has admitted a tax liability but he has not paid. This is the amount in arrear. Declarant, I told you earlier, declarant means the person under section 125 now comes section 126. अब मैं यहाँ पे one thing I can explain you कि how we can file this declaration. This declaration will be filed under the form SVLDR S1, which form has been prescribed under Rule 3. This will be filed online, electronically, and the site is cbigstgovernment.in, and this should be filed on or before 31st of December 2019. And this declaration will be filed separately for each cases. If declarant has 5 cases of disputed and he wants to avail the benefit under this scheme, so he cannot choose that he can take the benefit of 3 cases and should not take the benefit of 2 cases because he is confident that he will be likely to will in the appeal in respect of 2 cases, because under 2 cases the grounds of appeal are such which are favorable to him. But in 3 cases, the act is not in favor of them. Therefore, he wants in 3 cases I should avail, but in case of 2 cases I should not avail because I can win appeal. No. If the cases are pending, so he has to file the declaration under Rule 3 in respect of all the cases. He cannot select I can file out of 3 and not for the 2. All the cases he has to file, and this declaration will be filed for each case. All 5 cases cannot be combined in one declaration because tax dues amount in arrears will be different in different cases, and it will be very difficult for the designated committee to find out the amount correctly. But I can inform you, for your information, the department on site has already put your details of all these pending appeals, and they knew what amount is in dispute is pending with the department of the applicant, because whatever we will file, that will be verified electronic on site. So therefore, all data they have put on the site of the pending appeals and data. When we will file this declaration SVLDRT1 as per Rule 3, that will match with that data on the site. When it will match with that, the designation committee will verify the facts. Then they will issue they will do suggestion. Either amount will tally, either the designation department say the amount is not correct. Then they will inform the declarant in GIS STL 2, and they will provide an opportunity to them for the hearing. Then subsequently he can waive the personal hearing also. This other step I will explain you. Form 3 and 4 last is a discharge certificate. We are discussing filing of the declaration of this. This is as per Rule 3. This will be filed on or before 31st December 2019. Further, I told you separate declaration will be filed for each case. And another important point is, under this scheme, person or case is a different. It co-ed as the case, not of the person. They say it means then this specify under the Rule 3 a meaning of case Meaning of case, it means a show cause notice or one or more appeal arising out of such notice which is pending on or before 30th June 2019 or amount in area or an inquiry or investigation audit where amount is quantified on or before 30th June 2019. Another is the voluntary disclosure scheme. When we file this declaration with the department, then they will generate a electronic auto acknowledgement. Rule 4. Rule 4 does not prescribe any your this form. They say as per Rule 4, auto acknowledgement on receipt of this declaration and auto acknowledgement bearing unique reference number shall be generated by the system, and there's no specific form has been specified so far. Now we come to section 126. What will happen? Our declaration which will file under section 125, thereafter what will happen? The answer is section 126. They say your declaration will be verified by the designated committee. When a declaration filed a declaration under section 125 of the scheme, read with rule 3, thereafter designated committee shall verify the correctness of the declaration made by the declarant. It is important because the relief will be calculated in respect of the tax dues disputed. But as I told you earlier, in case of voluntary disclosure, the designated committee will not verify your declaration. They will accept as it is, and they will issue after making the payment. They will issue the discharge certificate to them. Issue comes in what is designated committee. Designated committee rule 5 prescribe the designated committee will consist of principal commissioner or commissioner of central excise and service tax, as the case may be additional commissioner or joint commissioners, as case may be, where cases and tax dues are more than 50 lakhs, and where it is less than 50 lakhs, then it will be constituted by the additional commissioner or joint commissioner of the central excise and service tax. Maybe the deputy commissioner or assistant commissioner of central excise, as the case may be. It means there will be two designated committee, where first will consider the cases which are more than 50 lakhs, and other committee will consider the cases which are less than 50 lakhs. So far, we have the information committee for cases where tax dues are more than 50 lakhs. They has been constituted only Trivandrum, Kochi, Kodinala, Trivandrum. They have constituted the committee so far. Other informations are not available at present. Now, we have filed a declaration. It will be verified by the designated committee. Then, designated committee will provide, if disagree with your amount declared in the declaration, an opportunity of hearing to you. And opportunity of hearing will be provided only once. And they can provide you the adjournment, only one adjournment. Wo adjournment be on the sufficient ground. Because this is a time-bound scheme, therefore, no adjournment is given after one adjournment, so that they can achieve the purpose in this scheme. As I told you in section 127, they say after the verification, the designated committee will issue a declaration, if the amount is as per declarant is tally with them, then issue SDR we have 3 as per rule 6.2 within a period of 60 days from the receipt of the declaration under rule 3.1. If your amount tallies with the system, then you will get SBLR 3 for making the payment of this amount, which has been accepted and verified by the committee, and that committee then will issue you SPDR 3 intimating that this is the amount due as you stated, and this statement will be issued within a period of 60 days. And provided that no such statement shall be issued in a case where the amount payable as determined by the designated committee is nil, and there is no appeal pending in the High Court or the Supreme Court. Now, as I told you, that where the designated committee, after verification of the declaration, find that the amount declared by the declarant in the declaration is not correct, then it should be higher to its estimate, then the designated committee shall issue an estimate. Then designated committee will tell you what amount according to them is to be there. In electronic form, SVLDR S2 within 30 days from the receipt of the declaration. And fortunately, they will provide you, I told you, for which they issue 2A, 2B form. When the declarant get the confirmation from the designated committee to pay the amount, then amount shall be paid. It should be noted, paid by electronic through internet banking within a period of 30 days from the receipt of the intimation. And it should be noted that this amount of duty cannot be paid by way of amount to be paid under the scheme shall not be paid through input tax credit account, except in certain cases, which we will again take in question and answer thereafter. Amount paid under the scheme shall not be refundable. This is an important issue. They say the amount which you have to pay, there are cases where in appeal you have taken the step and you have made a pre-deposit at the time of hearing. Under this scheme, government provides that that pre-deposit at the time of stay is to be adjusted against the amount declared by the declarant and accepted by the designated committee. If suppose as tax dues or tax in arrears comes 1,000 rupees and a person filed a declaration under section 125 for 1,000 rupees and committee also accept under the system if this amount is correct and he has to pay 1,000 rupees, and the intimation for making this payment is given to the declarant. But declarant once a time at the time of getting the stay deposit 2,000 rupees. Then this 2,000 rupees pre-deposit at the time of stay will be adjusted against this amount of 1,000 rupees. Therefore, the declarant needs not to pay anything. But government is wiser. They say the rest of the amount of 1,000 rupees will not be refunded. This, according to my view, this is not fair because government is entitled to get the legitimate due tax from the assessee. But government is right at its point. If we see other side of the coin, where government providing relief up to 70% on counter tax dues and areas and disputed amount. Therefore, government consider if we are one side, we are giving you the relief of 70% of the tax due. So whatever amount you have already paid, it is not going to affect you now cash liquidity. It has already been paid. Therefore, we will not refund that amount so that government should not lose their value. But it is advantage to the declarant in this scheme that he has nothing to pay more. And his appeal is deemed to be accepted because his dues are settled. In the same manner, if you pay the amount under this scheme on voluntary disclosure, even that the amount should not be refunded. And this amount which we will pay under this scheme, he will not be entitled to take any input tax credit on this amount paid. इसके अंदर one thing is more, where appeals is pending at the appellate form up to tribunal level. Then, after making this payment, or issue of the charge certificate as will come subsequently, those appeals pending with the appellate tribunal will deemed to be withdrawn. But there may be certain cases where appeals are pending at higher form, writ reference appeals under High Court and at the High Court and Supreme Court level. This scheme says you have to file the proof of withdrawal of those writ reference appeals before the High Court or the Supreme Court. But no pro forma has been prescribed under the scheme under which pro forma we have to take that. But when we move to the High Court or the Higher Court, then Higher Court will pass orders. That copy of order getting it scanned and sent along with your declaration that we share the proof of withdrawal of appeal at the higher level. Thereafter, on receipt of the payment of amount and proof of withdrawal of the appeal, as applicable, the charge certificate in electronic form SPDR S4 shall be generated and issued by the committee within a period of 30 days from the payment and proof of withdrawal of appeal of reference of it submitted, whichever is later. This shall be prescribed under Rule 9. Not Rule 9, I say. The charge certificate. When this committee, on being satisfied that the declarant has paid the amount in full amount as determined by it, as indicated in Form 3, and submission of proof of withdrawal of appeal or writ reference, as mentioned to Rule 8, they will issue a form electronically in SPLDR S4, which is called a discharge certificate, within a period of 30 days from making the payment or submission of proof, whichever is later. No. No question comes. There may be circumstances where there is a error. So, Section 128 take care of this thing. They say rectification of errors. They have given the power to the committee to modify its order on count of which kind of error? Arithmetical or clerical error. Arithmetical or clerical error, but this arithmetical or clerical error has not been defined under the statute. Okay, what will be the meaning of arithmetical or clerical error? Which, if time permits, I have a complete chapter on this issue. What is the meaning of arithmetical or clerical error? If these are appeared on the face of record. Now, what do you mean of face of record? Either as pointed by the declarant or as found out by the committee suo motu. In both circumstances. So it may possible, we are human being, that some error has occurred in respect of the amount which has been specified by the committee to the declarant. Or there may be some other clerical error in respect of date, in respect of name, in respect of amount. That error, if pointed out by the declarant to the committee, then this can be rectified, order can be modified within a period of 30 days of the date of issue of statement indicating the amount paid by the declarant. Then just see the word used within 30 days. It means if this error has not been pointed out within a period of 30 days from the statement which the committee has conveyed to the declarant, then this error cannot be rectified. They say the order is to be modified on account of arithmetical error or clerical error by designated committee within a period of 30 days of the date of issue of statement indicating the amount payable by the declarant. So one should be very careful and see that when he gets the intimation from the committee to make the payment, they should verify the correctness of this amount. Since I told you the arithmetical or clerical error has not been defined under the Act, under the scheme, the meaning we can take your arithmetic is, what is arithmetic? Arithmetic is part of mathematics. That is concerned with additions, subtraction, multiplication or division of numbers. In Hindi we can say कि अंकगणितीय त्रुटि हिसाबी गलतियां. The branch of mathematics concerned with numerical calculation such as addition, subtraction, multiplication and division. My dear friends, who have practiced for so long years this practice, I suggest that each and every word of the statute or the section has a meaning. And we should understand the meaning of each and every word. Arithmetical error can be on account of numerical calculation, because arithmetical means in respect of the numericality, such addition. If we say 2 into 2, they say 5, then we can point out that 2 into 2 is a 4. A clerical error, what can be a clerical error? A clerical error is an error which are occasioned by accidental slip or omission of the code, mentioning the date or mentioning that it should be paid on or before this date, but that date is not correct due to clerical mistake. It represents that which court never intend to say. Clerical means the court has never any intention to say that, but due to clerical mistake, it has been happened. It represents that which the court never intend to say. It is an error apparent on the face of the record. More important thing is on the face of the record. Face of record means it does not depend for discovery on argument or deputation. Arithmetic error is a mistake of calculation and clerical error is a mistake in writing or typing. This is decided by Saroj Devi versus Pyarela by the Supreme Court in the cases. And this mistake of arithmetic or clerical must be apparent on the face of record. On the face of record means if we take the documents and then we can find out where there is no argument, where there is no interpretation, where it does not need to elaborate the law. It on the face it appears. Then the order is sent, but it is not signed. When the order is sent, there is a mistake in that date, and which is apparent on the face of record. That can be rectified within a period of 30 days from the nation. Now say, section 129. Now we are discussing just the scheme of the act. In detail, we are coming in question answer also. Issue of discharge certificate to be conclusive on the matter and the time period. At the end, under section 129 says, when discharge certificate will be issued, then it will be the conclusive proof of the matter and the time period involved in that declaration. Number one, the declarant shall not be liable to pay any further duty, interest, or penalty with respect to the matter and time period covered under the agreement. These words, conclusive of matter and time period, is important. They say this will be the conclusive proof, and the declarant shall not be liable to pay any further duty, interest, or penalty with respect to the matter and time period involved in the petition. If there are 5 matters pending with the department for a particular year, then the declaration which is filed under this scheme in respect of those 5 matters in a particular year time, this will be related to that cases, because this act is not in respect of the person, they specify in respect of the cases. Then those cases only will cover under the scheme. If SECI has other cases with the department, they will not cover, they will not be affected. And further an important issue, when these cases are settled and conclusive proof comes, no further action taken, then it does not mean that department has accepted your grounds of appeal. Or you cannot take the advantage of this thing when in this particular year, this matter has been disposed of by the department and same issue is in the next year, so we can take the benefits of, we have settled this issue on this ground, therefore the same ground is the next year, so we should give the benefit of the same ground to the next year also. No. Department say neither the declarant nor the department will not take the benefit in subsequent period. And department cannot say, sir, you have admitted under the scheme in this particular year for this particular point, and same point in the next year, the department says, yes, we take against you in this period also. No. They say, when discharge certificates have been issued in respect of the matter which is covered under the declaration under this scheme in respect of the issue in the matter and the period. only that matter will be conclusive proof of settlement with the department after issue a discharge certificate under section 129 of the scheme. This action will not affect of the cases of the subsequent years. Or say the declarant shall not be liable to pay any further duty, interest or penalty with respect to the matter and time period which is covered under this declaration and discharge certificate has been issued. Then the big advantage is they say declarant shall not be liable to be prosecuted under the indirect tax enactment with respect of the matter and time period covered under this declaration. My dear profession, please understand. They say every time they say conclusive proof of matter and time period. Matter and time period means for a specific grounds of appeal, for specific time or year. And prosecution will not be taken place in respect of the issue and time period involved in the declaration, but if same issues or some other issues are there, on that ground, prosecution can be taken by the department against the declarant. They are saying that declarant not a prosecution under this act in respect of the matter and time period covered under the declaration. Third, no matter and time period covered by such declaration shall be reopened in any other proceeding under the indirect tax agreement. Other the basis of these observations under the declaration, on these basis, they cannot reopen your subsequent or earlier assessment or cases that under this scheme you have come, you have accepted this thing. Therefore, you might have committed the same mistake in a subsequent year, so that on the basis of your this declaration, we reopen your further proceeding. No, because they cannot reopen in any other proceeding. Yes. Now, they said notwithstanding anything contained in subsection 1. No person being a party in appeal, application, revision, or reference shall contend that the central excise officer has acquiesced in the decision on the disputed issue by issuing the discharge certificate under the scheme, which I told you earlier. No person being a party in appeal, application, revision, or reference shall contend that the central excise officer they have accepted the disputed issue by issuing a discharge certificate. The issue of the discharge certificate with respect to a matter of time period shall not preclude the issue of show cause notice for same matter for a subsequent time period or for a different matter for the same time period, which I told earlier. This will conclude only specific matter and time period. And as declarant cannot take the plea the department has accepted under for specific issue under this declaration, and therefore department should not reopen the case or cannot issue the SCL on the same issue which was the subsequent. No, this is only for a particular this scheme. In a similar manner, in a case of voluntary disclosure, where any material particular furnished in the declaration is subsequently found to be false within a period of 1 year, which I told you earlier, of the issue of discharge certificate, it shall be presumed as if the declaration was never made and proceeding under the applicable indirect tax enactment shall be instituted. Then, where person makes the voluntary disclosure, then he has to wait up to period of 1 year should lapse. Otherwise, if we file wrong declaration or false declaration, or the department finds out subsequently that there is a mistake, there is a false declaration, then they can reopen within a period of 1 year from the date of issue of discharge certificate. Section 130 is posed to the restrictions of scheme. Restriction of scheme, they say, any amount paid under this scheme shall not be paid through the input tax credit account under the indirect tax enactment or any other act, shall not be refundable under any circumstances, shall not under the indirect enactment or any other act be taken as input tax credit, or entitle any person to take input tax credit as a recipient of the sizable goods or taxable services with respect to the matter and the time period covered under this declaration. Section 131, they specify removal of doubts, and 132, power to make rules. They have given the power to the government, as a central government, to make the rules to carry out the provision of the scheme. So wherever there is an act, if they are not corresponding rule of that act, then that act cannot be worked out. So you will find always when there is a particular sections, there are sections which specify under the statute, under the act, then you will find subsequently the rules tells how this section will work. If you find any particular section in any statute, not in this scheme, any statute, where you find there is a section, there is an act, they provide under the scheme to do certain things in a particular manner, then unless there are corresponding rules which will specify how this particular section will work out, then cannot be worked out without rules. Therefore, this scheme under section 132 prescribe the power to make the rules. The central government may make rules for carrying out the provision of this scheme, and these rules, whenever they will be notified under the Gazette, and this is settled proposition of law that when these are Gazette, then on that date they are applicable from that date of Gazette. At present, there are 9 rules made, and Constitution of the Dissented Committee also they have prescribed the rules, and they say if they have to modify the rules, then they have put before the both of the houses as early as possible, and where both houses agree for making the rules or modification in the rules only, then rules shall have the effect. It is important to note that any such modification or annulment shall be without prejudice to the validity of anything previously done under the rule. And one thing is more important, you see, you must have experience that certain provision of the act or the rules are sometimes applied retrospectively. Retrospective effect means these particular rules are deemed to be effective from this particular date. From the date they have come into operation, but they say we are informing today, onset 2019, and we say this particular rule with retrospective effect 2015. Then this rule will have effect retrospectively. But it is also set a law. The advantage or the benefit which has been allowed and given under any statute, that cannot be taken away by making the amendment retrospective effect. Under this scheme, it is important to observe that whenever they make a rules, all rules will be applicable prospectively, not retrospectively. So whatever rules we see now today, and what all these 9 rules prescribe the procedure, the government cannot rectify the things which have been mentioned under these 9 rules with retrospective effect. Now, 133 section says power to issue orders and instructions. Our statute provides these provisions for the Central Board of Indirect Taxes and Customs. Still, we are finding daily notifications, circulars, instructions, directions from the Central Board of Indirect Taxes and Customs in respect of clarifications or in respect of provision of certain act and rules which will be effective. So therefore, they have a specific power under rule section 133 to issue order and instructions. I will in the last I will tell you what is the latest circular and notification they have issued. So far till today, they have issued a FAQ circular number 107/1/04/2019, 27 August 2019. This circular kindly note, and this circular explains the various points mentioned in the scheme. E-flyer on scheme, advisory on the SBL scheme, step-by-step guide on SBL scheme. They have prescribed Sabka Vishwas, total procedure providing how you will click, how you will file a declaration, under which form, number 1, and what step you will take subsequently filing a declaration. All this they have prescribed. Until so far, all this guide has been issued. And this is subsection 2 of section 133 says that the CBI has power to issue general or special orders in respect of any class of classes. Now, section 134, they say removal of difficulties. This section we also find on all the statute. Simply the reason that if some difficulty comes in applying the provision of the statute, then they have power to removal of difficulties. It is sometimes found that there are certain clarification requires and difficulty arises while working under the scheme for giving effect to the provision of the scheme. The central government has provided under this section to remove any difficulties which arises under the scheme from time to time. It provides the time limit of 2 years. Why time limit is prescribed of the scheme is only due to the reason this scheme is open only for 1st September to 31st December. Therefore, this short period, it opens on 1st September and will close on 31st December 2019. Then the period of this scheme is very small. Therefore, we have noticed that prescribed a period of 30 days, 60 days. If mistake is pointed out within a period of 30 days, then they can take an action. And the committee has to inform to the person within 60 days. But I'm insisting that they have issued instruction that in respect of the petty cases where amount is not involved much, then designated committee has been given instruction by the department to settle all this issue within a period of 15 days. Less than 50 lakh rupees involved. Then they said expedite the matter. Then the committee will settle this issue within a period of 15 days. Where the amount is involved above 50 lakhs, then they have said they should decide within that period of 30 days. Therefore, here also removal of difficulties. They say it also provides a time limit for 2 years from the date of the scheme comes into force. Whether it is important to note, the order cannot be inconsistent with the provision of this scheme. Whatever order is made by the committee, this should go with the spirit of the scheme and the procedure laid on the scheme. It should not be inconsistent with the provision of the scheme. अर्लियर इसी जब सर्विस टैक्स के अंदर ये स्कीम आया था तो उसमें भी सेक्शन 172 सर्विस टैक्स के अंदर का भी इन्फोर्स था. अब now comes section 133. This provides protection to the officers. Although this section has nothing to do with the declarant, but for the purpose of the officer of the department, this section is important. This section provides protection to them. This section has nothing to do with the declarant. It will provide the protection to the central government and any officer of the central government. What kind of protection they are given to them when discharging their duties under the statute? One, no suit, prosecution, or other legal proceeding shall lie for anything. This word is anything, the very wide word. No suit, prosecution, other legal proceedings shall lie for anything which is done or intended to be done in good faith. A good faith has not been defined. Next, we'll discuss the misconduct also. That word also not be defined. They said done in good faith. What is the meaning of good faith? No proceeding other than a suit shall be commenced for anything done or purported to have been done in pursuance of this scheme or any rules made thereunder without giving a prior notice of not less than 1 month in writing of the intended proceedings and of the cause thereof, or after the expiration of 3 months from the accrual of this cause. This period is very short, and this period saved the skin of the government officials. They say, if you have to take the action under this scheme, then you have to give a notice of not less than 1 month time. In writing, giving the reason and the proceeding you are want to take under this scheme. Or if 3 months have expired from the cause of this action, then no further action can be taken. It means if he has done anything during the period of 1st September to 31st December, then within a period of 3 months, action can be taken. But if 3 months has passed, then no action can be taken. If you think safely, the 31st December is the last date, then no action can be taken after the expiry of the 31st March. But in between also, if the officer passes any orders in September, October, then this period comes very short. No proceeding shall be commenced only on the ground subsequent deduction of an error in calculating the amount of duty payable by the declarant unless there is evidence of misconduct. The word misconduct also has not been defined. By making this chart, the term misconduct has not been defined under the scheme. However, misconduct can be of various kinds and depends on each and every facts and circumstance of the case. Misconduct. It includes something seen as unacceptable as well as criminal offense. Then misconduct can be of gross misconduct. It can be a criminal misconduct. It can be an official misconduct. It can be intentionally wrongdoing. In law, misconduct is wrongful, improper, unlawful conduct motivated by predatory or intentional purpose or by optional indifference in the consequence of one act. Or no further, they say, if it happens on account of misconduct, then they have not prescribed any criteria and the procedure. But according to other rules, in case of gross misconduct, department should adopt a certain procedure, taking the investigation, interviewing the person, witness, provide them the person a personal hearing, because principle of natural justice should not be violated. In all these things, there are time. I consider this arithmetical error or clerical error. What is the meaning of arithmetical error and clerical error? I have in detail with me this whole of the scheme and this complete chapter on arithmetical clerical error with various judgments, which can be helpful. The core case law we have discussed, which can be helpful not in respect of this statute only, but in respect of other statutes also, where you find mistake happened on record due to arithmetical or clerical error. And now we can discuss this scheme as in the form of question and answer. If you have any query, you can send to me. I will answer right now, or otherwise we'll go with the question and answer under this scheme, and thereafter I will again take up this issue in detail. These all case law we have given due to paucity of time. This case law cannot be taken up here, but certainly we can discuss this scheme in the form of question and answer. And I take just a wait a few minutes. This section we have discussed, and these rules we have discussed. These are the forms. There are 6 forms in fact. 1, 2, 3, 4, 5, and 6 forms. As I told you, this form 1 is a declaration under section 125 of the Finance Act. Read with rule 3. Form 2 is the estimate under section 127. 2A में they will say the written submission अगर when declarant can file waiver of personal hearing or adjournment. Adjournment I told you earlier, only one adjournment will be given, or if you have a reasonable ground as per rule 6. Then 2B is the intimation. Form 3 under section 127 will come by the committee, and form 4 is discharge certificate, which will be the full and final settlement of the tax dues under section 127. This can be read with rule 9. These are the forms which you can take from the site, and form 1 has 12 columns where they have few questions asking from the declarant. If answer of even one question is no, then he will not able to find the question. No. Understand scheme in respect of the FAQ. Now, for the purpose of repetition, so who is eligible to file declaration under the scheme? They say any person falling the following category is eligible. So I'm repeating to the reason, you may going to get refresh. And you will remember this. Any person falling the following category is eligible, subject to the other condition under the scheme to file a declaration. Again, I repeat, where show cause notice of duty or one or more appeals rising out of such notice pending and where the final hearing has not taken place as on 30th June 2019. Who has been issued a show cause notice for penalty and late fee only and final hearing has not been taken place as on 31st June 2019. Final hearing has not taken place is important words. They say we will cover only those cases in respect of which final hearing has not taken place. Why? Why so? The reason is where final hearing has been taken and the department has taken a view in respect of your tax disputed amount, and there may be cases you get a relief, there may be cases you are not getting any relief from the department. And when you say the final hearing has taken place and you find that it is may possible, may not possible to get any relief, and you say, yeah, I want to come in the declaration because hearing has been final and department is not likely to accept my plea and order is likely to come against me. So they said no. When final hearing has been taken place, opportunity to you have been given, then in respect of those cases, you cannot come under this scheme. Who has recoverable areas pending and where the cases under investigation and audit, whether duty involved has been quantified and communicated to the party or admitted by him in a statement on or before it. Who wants to make voluntary disclosure? These are the persons who are covered. There are cases where investigation is going on, audit is going on, and they have set certain issue caught up under the audit, and they have quantified the amount of duty also under the proceeding, and that duty is communicated to the party, and he also admitted as on before 30th June 2019, those persons can file the declaration, and under this scheme, not only deciding the disputed issue, they have given the amnesty scheme for voluntary disclosure also. What act was covered? I told you these are tax covered with 26 says. Then they say if an inquiry or investigation or audit has started, but the tax dues have not been quantified, whether the person is eligible to opt the scheme. They say no. If an audit, inquiry, investigation has started and amount of duty payable has not been quantified on or before 30th June 2019, person shall not be eligible to opt this scheme. Why? There is a reason. Department started investigation, department issued a notice for audit, and they have started the proceeding. During the course of proceeding, amount of duty could not be quantified as on before 30th June 2019. When the amount of duty has not been quantified, then what is the amount of disputed tax? What is the amount of tax dues? You cannot find out. Therefore, they say where inquiry is pending, amount has not been quantified, then you cannot avail this scheme. Next, if SCN covers multiple issues, whether the person can file an application under the scheme for only few cases covered under the SCN, which I told earlier to you. No, he has to go under the scheme in respect of all cases together. He cannot be choosy for 3 cases and not taking under the declaration 2 cases. No, all cases he has to file together. Then says what is the scope of tax relief cover under section 124(1)(b) with respect to SCN for late fee and penalty only where the amount of duties is the said notice has been paid or nil. They say in case of voluntary disclosure or in case of this SCN for late fee and penalty, where amount of duty is nil, the tax relief shall be entire amount of late fee and penalty. Or where the amount of duty has been paid as specified in the SCN, or where it is nil, then the relief is very good. It all the late fee or penalty will be paid. Next question comes. I have filed an appeal before the appellate forum. Commission appeals, second, and such appeal has been heard finally on or before 30th June 2019. Am I eligible for the scheme? They say no. When appeal has been heard finally, you cannot go for the scheme as provided in section 125(1) clause A. And then what is the scope of the scheme? When anticipation order determining the duty for tax liability is passed and received prior to 30th June 2019, but the appeal has been preferred on or after 1st July 2019. They say no, such person shall also not be eligible for filing a declaration. Because they have filed the appeal after 30th June, then no appeal is pending before 30th June 2019. They have given the cutoff date. 30th June 2019. Therefore, we should be careful in determining what is the tax due as on 30th June 2019. And those cases where final hearing has not taken place. Now, next question. If I have been convicted for any offence punishable under provision of the indirect tax enactment, am I eligible for the scheme? They say a person who has been convicted for any offence punishable under any provision of the indirect tax enactment for the matter for which he intends to be file a declaration shall not be eligible for the benefit under the scheme. But pending prosecution, they can take the advantage. When discharge certificate will be issued, then pending prosecution will also go. And further, no prosecution can be taken against the declarant only in respect of the matter and period involved in this case. Only specific case, specific period in respect of which declaration has been filed, in respect of which discharge certificates have been issued, only in respect of those cases, no prosecution. In no interest, no penalty. And relief goes maximum up to 70% of the tax. It is a very big relief. Now they say, I have been issued SCN under indirect tax enactment and a final hearing has taken place on or before 30th June 2019. I am eligible for the scheme. They said no. I have been issued a SCN under indirect tax enactment for an invoice refund. I am eligible for the scheme. They said no. If you are wrongly or fraudulently claim the refund, no. I have been subject to an inquiry or investigation or audit under indirect tax enactment. An amount of duty involved in the said inquiry or investigation audit has not been quantified on or before 30th June. No. I've been subject to an inquiry, investigation, audit under indirect tax enactment. I want to make voluntary disclosure regarding the same. I'm eligible for the scheme. They say no. Because department wise, I became wiser. When they say we have caught the person and inquiry has been taken up, audit has been started, investigation has been started, so why the department will go for settlement for less amount? And moreover, amount has not been quantified during the course of investigation. And department advisor, they say we can the amount of duty may be higher after the investigation is over, may be higher. So why they would like to give the relief? They will not give any relief. And moreover, relief of interest and penalty is payable 100%. So therefore, they said under section 125 clause 1 F1 of the scheme, they said no. Where inquiry or investigation or audit is pending, have been started, then no declaration. Because I want to make a voluntary disclosure after having filed a return under the indirect tax enactment, wherein I have indicated the amount of duty as payable, but the same has not been paid. The I am eligible scheme, you cannot make the voluntary disclosure in such case. However, you can still file a declaration under Section 125. And I have filed an application in Settlement Commission. This is important question. I have filed an application in Settlement Commission for settlement of the case. Am I eligible for the scheme? Yes and no. All the cases which are pending before the Settlement Commission, you are not eligible for that. Unless and until Settlement Commission refer back to them. Then they say, I deal with the goods which are presented under central excise and is mentioned in the fourth schedule to the Central Excise Act 1944. And you cannot take the advantage of that because government has excluded, as I shown, the tariff heading 2401, 2701 of the Central Excise Act 1994. All items which we see, they are mainly covered the tobacco product. In respect of those excisable goods and the amount of size in respect of the goods mentioned in fourth schedule, we cannot go under that scheme. Arnaud said, how will I apply for the said scheme? And all such persons eligible under the scheme shall be required to file an electronic declaration at the portal cbscgst.government.in. Said, and when I get the acknowledgement, yes, I told you in Rule 4, when you file declaration online, auto acknowledgement, electronic generated will come to you and they will intimate the reference number, unique reference number, which has been generated. Of now, declarant say, how will I come to know about the final decision taken by the committee on my declaration? They say within a period of 60 days of filing of the declaration, the committee will inform you electronically about their decision. What is the difference between tax dues and tax relief? The tax dues is the total outstanding duty demand, and tax relief is the concession which the scheme has provided. This I have told you about the tax dues. Now, I have been issued SCN under any of the indirect tax enactment on or before 30th June 2019. What will be the tax dues? Although I explained you the meaning of tax dues under Section 123, now they say a tax due as per Section 123B will be the amount of duty, tax, cess. Why they use the word cess here? Because under Section 122, 3 enactment cover plus 26 cess under different agricultural cess, under different cess, they are covered. Therefore, they say amount of duty, tax and cess stated to be payable in the SCM. That amount will be the tax due which they have stated. If we have gone in appeal and amount has been reduced, then that reduced amount will be the tax due. Then say, what is the scope of coverage of critical SCN under the scheme? Critical SCN means declared person must have received 1 to 3 SCN on different issues, and any SCN, whether male or critical, issued and where the final hearing has not taken place on or before 30th June 2011 are eligible under the scheme. The advantage of the scheme, I told you earlier, total waiver of interest penalty and in some cases fine, immunity from prosecution, and 70% up to the duty demanded as a relief if it is less than 50 lakh, more than 50 lakh, then 50% is the relief. In case of mountain areas, relief is 60% of the confirmed duty. If less than 5 lakh, 50 lakhs, then 40% in other cases. For voluntary disclosure, the full amount, so he has to pay the full amount of restored duty and waiver of interest and penalties there. If we see now the scheme of that, my dear friends, to my knowledge, this is the best scheme, and the relief which the government has offered is a great relief. You just see if mounting dispute is 100 rupees and litigation is pending for a considerable time, and Shashi must have spent a considerable amount on account of professional fee also. Then government say you pay 30% and get rest. 70% relief is a big amount to my knowledge. And moreover, total waiver of interest and penalty. I think if this scheme gets success, which I feel should get success, then this scheme can be extended to, this is my observation, can be extended further up to 31st March 2020. It all depends how much government gets revenue and how the government thinks proper. But I'm confident all the SSC will get benefit and they must go for this scheme. And those cases where pre-deposit is higher than the amount calculated in this scheme, so then the person has nothing to pay. And he absorbed from the litigation with the department at least up to appellate tribunal. So once he will file the declaration, all the appeals which are pending up to the secret tribunal, appellate tribunal, all deemed to be taken as withdrawn and settled. The person is not required to file any application of withdrawal appeal at appellate tribunal level. Only in the case of the writ reference appeal in the higher court, the Honorable High Court, the Honorable Supreme Court, then the person is required to go before the court and withdraw that appeals, writ reference, whatever it is, then file the proof of that withdrawal with the department and make the payment and get the. But at the criminal level, it is finalized. Next. Shall the pre-deposit rate that I have just discussed, but disadvantage only this, if amount of pre-deposit is higher than the amount calculated in the declaration, that amount will not be refunded back. I think that is also one should waive off because he get the peace of mind and get his case settled also. Because one never knows what will the outcome of the appeal at the tribunal, may go in favor of a SSC, may not go in favor of the SSC. Then the SSC will be in great difficulty after the lapse of this scheme. Then question comes, how the declaration made by the declarant under the scheme would be verified. I told you the designated committee which had been formed by the government there will be two designated committee. One will decide the cases which are above 50 lakhs. Other committee will decide the cases which are below 50 lakhs. And declaration made by the declarant will be verified by that committee. And when that committee is satisfied the particulars are correct, they will communicate to the declarant their decision and ask him to pay the amount as declared. Now they say if amount is different, and they say whether the declarant will be given a opportunity to being heard or not. But yes, not in India. If you go in the whole of the world, principle of natural justice cannot be violated. Wherever you go, in any act, in any statute, principle of natural justice has to be followed. Therefore, they say, subsection 3, section 127, they say, if estimated filed by the declarant is different amount which this committee calculates or communicates, then the committee says, sir, kindly we provide you the quantity, please tell us if your amount is 1,000 rupees, according to us, it is 1,200 rupees. Kindly explain why we should not ask from you to pay 1,200 rupees. Then they say, fine, we provide you an opportunity, but you don't take that it is an endless job. We're providing opportunity and providing you further only one adjournment. And that adjournment too on the sufficient ground shown, sufficient reason to show, then one adjournment will be given. So that this case should be settled within the time frame. Now they say, what will the procedure and time period of payment to be made by the declarant? They say declarant will pay electronically, internet banking, within a period of 30 days from the statement communicated to him by the committee. Yes, then they say what procedure will be followed. For withdrawal of appeals where the person has filed declaration under the scheme, which I told you earlier, he has to make application for withdrawal of this and proof of that withdrawal, which he will get from the court. A scan copy of that can be communicated to them, can be sent to them. Whether any certificate will be provided to be declared as proof of payment of dues? Yes. The department on the payment of the amount indicated in the statement and production of the proof of withdrawal of appeal, wherever it is applicable, the committee shall issue a discharge certificate in electronic form within a period of 30 days from making the payment or filing the proof whichever is later. Error, I told you earlier, they can rectify the error within a period of 30 days if pointed out by the declarant or suo motu also. The advantage of the discharge certificate, I told you, that it is absolved from all the issue matters in respect of the matter and period involved in the declaration. No further tax is required to be paid, and no liability is there, no prosecution, no interest, no penalty. They say, can I take input tax credit of the amount which you have paid? They say no. You cannot take the input credit or the tax paid. Then they say, can I pay any amount under the scheme through the input tax credit account under the tax enactment or anything like that? Say no. Refund, I told you, under any circumstances, amount paid under the scheme will not be refunded back. If in pre-deposit, this amount is higher, even then it will not be refunded back. In voluntary disclosure scheme, voluntary disclosure declaration, no amount will be refunded back. Benefit they have already given in respect of the prosecution. Discharge certificate, they say whether discharge certificate under the scheme would serve an annuity against issue of SCN for the same matter for a subsequent time period. No, no. It is very clear, and keep in mind that all things shall be settled only specific matter or specific issue as in respect of the specific period. It has nothing to do earlier, it has nothing to do subsequent. They say, what action should be taken against a declarant who makes false voluntary declaration under a scheme? I tell you, if under the voluntary scheme you make any false declaration under section 129 subclause C, if they find within a period of 1 year, in case of voluntary disclosure, the government has taken a wider period of time, 1 year. But in respect of the other declaration, period is 60 days, somewhere 30 days. But in case of voluntary disclosure, why it is so? Because in case of voluntary disclosure, the government has nothing to verify. Government has nothing to verify, and government cannot verify what amount was outstanding against the person. Therefore, in case of voluntary declaration, there is no verification by the decisional committee. They will accept what amount you have shown. But they have made a provision for 1 year. If they found subsequently, after filing your declaration, period of 1 year, that any false declaration was there, any mistake was there, then they can reopen your declaration, and declaration which you have already filed with them, that it will presume that the person has not filed any declaration. That will have no any meaning. The department representation. No, I sum up. So friends, this was all about this scheme, and I have also discussed with you the questions and answers which have been provided by the government. And in this, I have written this book on this subject, and this book contains more than 250 pages, and I have given in detail in this book with case law. And let us discuss in 5-10 minutes the what we can say. If I can get it, Mm, it's not coming up. We can discuss the latest circulars. This has disappeared. Mm, if my dear friends, I'll find out if it comes on the computer. In the meantime, my dear friends, if you have any kind of question, I'm here. You can ask me, or you can send me on my mail or Raj Chawla mail. We can answer that question. And in my book, this Sabka Vishwas, Legacy Dispute Management Scheme 2019, which will come in market after a week time, in which we have not only discussed the scheme, rules, performance, question answers, but we have taken up the case law, and we have given the meaning of certain words which has not been specified under the Act. How we can interpret them. Interpretation of that word also given. And the minutes of the uh, council meeting, GST council meeting, were also given there. Here given in this scheme, and in the form of PPT in my book, we explain whole of the procedure step by step, how this scheme will work out and how you can establish it. Thank you very much, my dear friends, for your patient hearing. And I'm grateful to you that you have, I had this opportunity to interact with you on this webinar. Thank you very much. हाँ जी, how it will work. If I can find out the latest circular, then I will discuss with you. These are all total scheme, how to work. These are notification circular and latest circular they have given. Which come out. These are forms which they are prescribed. This is a national committee which they have formed in Trivandrum only. I think it is a yes, 37th GST Council meeting press release. This corporate tax rate slashed to 22% for domestic companies and 15% for new domestic manufacturing companies and other official date. 20th September 2019. They have given the press release, they have given the relaxation filing of annual returns for MHC for the financial year 2017-18 and financial year 18 and 19, and waiver of the requirement of filing GST 9A for composition taxpayer for the said tax period, filing of GST on 9, those taxpayers who are required to file the said return, but the aggregate turnover is up to 2 crores, made optional. When we discuss the issue, we think this has been total waived. But the government is saying otherwise, if you want to file, you can file it. They make it optional. Filing of STR 9 in case of your turnover is up to 2 crores. Obviously, all the circles there, I just see. Clarification they have given as regard to applicability of GST rate in respect of the certain goods recommended by GST Council. The mere heating of lamination vegetable for removing moisture or soften and puff it or removing the skin and not subjected to any other processing or addition of any other indigenous salt would be classified under SCN code 0713. Mechanical spare, they have been specific SCN code 8424 by the rate of 12%. These are the latest notification of 30th September 2019, 43 of 2019, which make the amendment of the notification number 14 over 29. Another is 14 over 2009, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25. That 25 is important. That seek to notify the grant of alcoholic liquor license, neither supply of the goods nor supply of services. Therefore, on the liquor license, there will be no GST. Thank you, friends.